Hi everyone, this is Eva Mayer from the Floyd Zadkovich firm. I'm going to be talking about 1782 applications and what that all entails, and some similar methods that you could use in an English court proceeding. So listen in and hopefully you'll find this educational.
Floyd Zadkovich, International Commercial Lawyers.
Hi, my name is Eva Mayer and I'm an associate with Floyd Zadkovich in the New York office. Today I'm going to be talking a little bit about a 1782 application and its use to international litigations and arbitrations. So what is a 1782 application? A 1782 application is found in 28 U.S.C. and its formal title is the assistance to foreign and international tribunals and to litigants before such tribunals. So that doesn't say much. Essentially, a 1782 application allows international litigants to file an application with a U.S. court to obtain discovery from either a party in the proceeding or also a third party that is located within that district that is relevant to the current litigation. One of the perks of such an application is that, of course, you get the full scope of the federal rules of civil procedure when it comes to discovery. The discovery rules in the US are generally a lot broader than they are elsewhere in the world, so that can be very useful. So how does one go about applying for such an application? Well, there are several steps that you have to show in order to obtain the granting of such an application. And just to go back, the idea behind an application like this is to provide efficient means to assist parties that are involved in international proceedings. And also the idea is that if the U.S. provides such a means for the other country to reciprocate that, that doesn't necessarily happen, but that is one of the goals. So how does an applicant go about obtaining an application? Well, the applicant would go to a district court where the party is located. So it's about the jurisdiction of the person or company that you want to obtain those documents from. They can either be a third party or they can be party to the suit that you are obtaining those documents from, but they have to be located in the jurisdiction. It's not about the location of the documents. It's about the location of the person, similar to general jurisdiction requirements in the US. So a 1782 application has three requirements. I already spoke about the first one, namely that the person needs to be located within the district. So the district court has to have jurisdiction over that person. Secondly, the discovery sought must be for the use in a foreign proceeding. So you can't just go and file an application requesting discovery completely out of the context of a foreign proceeding. And the application can't be made by anyone. It has to be made by an interested party. And that means either a party to the proceeding, but also, let's say, a court that is overseeing that international proceeding. There was a landmark case back in 2004, which is the Intel Corp case, which required 4 more elements to be shown by the applicant in their application. The first one being whether the person from whom the discovery sought is subject to the proceeding or whether they are a third party, the nature of the foreign tribunal, and the character of the proceedings that are underway abroad, and whether or not the application is trying to circumvent discovery restrictions in the foreign proceeding, because what a court in the U.S. doesn't want to do is enable a party to circumvent the regulations and rules that it has to abide by in the foreign tribunal. So why use such an application? Well, It's really great because you can obtain both verbal as well as documentary discovery from either a third party or from a party to the suit. You have access to the very broad discovery rules of the United States, which you usually wouldn't get in other states. And also because contracts and litigation is becoming more and more international. And so being able to rely on such a great tool can be very useful in such proceedings. So that is from the US perspective, or at least the ability under the US law. The English law is a little bit different. It doesn't have the equivalent of the 1782 application. However, should there be a litigation that requires documentation that is located with a person in England to be used in a foreign proceeding, the tribunals overseeing such a proceeding can request the discovery from an English court. It would have to be an application to the English court using the process of letters rogatory, for example. However, the Evidence Act of 1975, specifically proceedings in other jurisdictions, do provide jurisdiction to English courts to grant such applications. However, they're not being brought, directly from one of the parties to a court in England. So it's a little bit more cumbersome. However, the English courts do acknowledge the evidence that is, or documents that are obtained through a U.S. 1782 application. And they acknowledge and will review documents that were obtained through a direct application to a U.S. court, but they will also allow parties to a suit to request an application to the English court using 1782, which they will then use through letters rogatory, for example, and request those documents or request such an application to be granted in a U.S. district court. And why would someone use the second option of having to go through an English court to apply to a U.S. court when you can go directly to the U.S. court and get your application hopefully granted? Well, one consideration might be costs. In the U.S., generally, you don't get costs of the litigation back, even if you are the one who prevails in the case. In the UK or in England, in English law, that's a little bit different, and the odds are that you can get that back if you are the prevailing party. So that's definitely something to consider. But generally, a 1782 application can be a really neat tool in your toolbox when you're dealing with international litigation that has to do with U.S. parties or documents are located in the U.S., especially because the documents obtained through such an application don't have to be admissible in that specific court. That means that you get to see a lot more documents than you would be able to maybe through the foreign court and discovery rules. It's then up to the court to decide whether or not to admit certain documents that you've obtained. And that's actually another note on going through the English court, for example, to obtain a 1782 application. When you go that route, even though you may be able to get your costs reimbursed, those applications right off the bat have to meet the discovery requirements under the English law. So you would be receiving most likely a more restricted universe of documents. But yeah, it's all up. It all depends on what your goals are and the type of document that you are trying to obtain, and whether or not costs are a big issue. But it's something to keep in mind, and especially as things are getting more intertwined, different jurisdictions, different parties all over the world. It's a good tool to keep in your back pocket, and I hope that this video has helped you and given you some insight on the 1782 application. And we hope to see you here again soon, and watch out for additional videos.